Hello everyone and welcome back to our channel. Today we have an insightful topic to discuss, the Industrial Disputes Act 1947. This act plays a crucial role in shaping the industrial relations in India. Let's dive into the key objectives and provisions of this act and breaking down its various aspects for better understanding. Firstly, the Industrial Disputes Act 1947 is known for its comprehensive approach. It's not just a set of rules, but a framework with 7 chapters and 40 sections. This act applies throughout the India and was enacted on 1st April 1947. Now let's explore the significant objectives behind this legislation. The act has a multifaceted purpose, promoting cordial relations. This act strives to create a positive atmosphere between employees and employers. Dispute resolution. This act establishes different mechanisms like labor courts and tribunals to resolve disputes effectively. Investigation and settlement. This act provides a suitable mechanism for investigating and settling industrial disputes. Prevention of illegal strikes and lockouts. This act aims to maintain stability by discouraging illegal strikes and lockouts. Regulation of layoffs and retrenchment. It ensures fair treatment for workers during layoffs and retrenchment. Guidelines for labor practices. It sets standards to promote fair labor practices. Promoting collective bargaining. It encourages employees to negotiate collectively for better terms and conditions. Now let's delve into some important definitions under Section 2 of the Act, which clarify scope and application. Award. The conclusive determination of industrial dispute made by authorized bodies. Employer. It encompasses government authorities, heads of departments, and local authorities. Industry. A broad term covering diverse business activities, services, employments, handicrafts, and industrial occupations. Industrial dispute. It encompasses to any disagreement related to employment, unemployment, or terms and conditions of labor. Layoff. Defined as the failure, refusal, or inability of an employer to provide employment for specified reasons. Lockout. Temporary closure or suspension of work by an employer. Retrenchment. Termination of employees by an employer due to economic reasons, excluding certain situations like voluntary retirement, termination due to continued ill health. Settlement. A broad definition that includes agreements reached after conciliation proceedings or any agreement signed by involved parties. Strike. A cessation of work by a collective body of employees acting in concert. Wages. The detailed definition encompasses various forms of remuneration, allowances, and exclusions. Workmen. An inclusive definition covering wide range of workers engaged in different capacities. The Act establishes several authorities to address industrial disputes. First up, we have the Works Committee, a joint platform for employers and employees' representatives to discuss common issues. Then we have conciliation by the involvement of third party and the Board of Conciliation, the more formal mediation process. They all play crucial roles. Additionally, the Act allows for arbitration and adjudication by specialized bodies like labor courts, industrial tribunals, and national tribunals. Now let's talk about changes in working conditions. Section 9A mandates that an employer must provide a 21 days notice to workers before making any changes. This ensures transparency and provides an opportunity to affected workers to voice their concerns. The industrial tribunals and labor courts wield significant power. They have the authority to modify punishments like dismissal or discharge and provide appropriate relief, including reinstatement. If a dismissal seemed unjustified, these bodies have the authority to overturn the decision and order reinstatement. This act grants specific duties to various authorities, including conciliation officers, boards, courts, and specialized bodies like labor courts, industrial tribunals, and national tribunals. They all play crucial roles in facilitating communication, investigating disputes, and ensuring fair resolutions. Transparency is key. The reports and awards must be published within 30 days of receipt by the appropriate government. Once published, these awards are considered final and cannot be challenged in any court. Workers have rights too. Section 17B ensures that if a worker is reinstated and the legal proceeding challenging the reinstatement are going on in the higher courts, the employer must pay the last drawn wages to the worker. Settlements, awards of arbitration, or awards of labor courts are not just binding on direct parties involved. They also extend to others summoned to appear during the proceedings and relevant employers and employees. The Act outlines the period of operation of settlements and awards. The settlement come into operation on an agreed upon date or within 6 months if not specified. The award remain operational for 1 year after the enforcement. The Act mandates that before workers embark on a legal strike, a notice must be served to the employer at least 6 weeks prior, with a critical stipulation that no strike should occur within 14 days of issuing the notice. Strikes often tool used by workers to exert pressure and lockouts used by employers to do the same. But both are restricted during the conciliation proceedings and 7 days after their conclusion. Section 23 reinforces general prohibition. No lockouts or strikes during the pendency of proceedings before a board, tribunal, or court. The Act deems strikes or lockouts violating Section 22 and Section 23 as illegal. If a strike or lockout is already in progress when an industrial dispute is referred, it is deemed as illegal. However, there are exceptions. If a lockout resulting from an illegal strike or a strike declared in response to an illegal lockout are not deemed as illegal. However, layoff defined as the inability of the employer to provide employment due to various reasons. This requires compensation for workers who are to be laid off, but on the condition that they must be working for more than 1 year. This compensation is set at 50% of basic wages and dearness allowance. Importantly, in general cases, no worker can be laid off without the prior permission from the government. Retrenchment or termination of a worker's service has specific conditions. A 1-month notice or equivalent wages, along with compensation based on years of service, is mandatory. Section 25N outlines the various conditions precedent to retrenchment. Both employers and employees can face penalties for engaging in unfair labor practices. Schedule 5th provides the guidelines for fair treatment and collective bargaining rights. Closure procedures are stringent. A 60 days notice is mandatory and specific forms must be submitted to the labor authorities. Closure involving a significant workforce requires a government permission obtained at least 90 days prior. Employers cannot alter conditions of service during proceedings without the permission of competent authority. Approval is required to impose punishments on the disputed workman. Various penalties are in place for offences ranging from unfair labor practices to illegal strikes, instigation, providing financial aid, breach of settlement, disclosing of confidential information, and closure without notice. In conclusion, the Industrial Disputes Act 1947 serves as a legal comprehensive framework addressing the intricate dynamics of industrial relations, dispute resolution, and the protection of rights and interests of both employees and employers. If you found this information helpful, please make sure to like, share, and subscribe to our channel for more educational content. Until then, keep exploring, keep learning. I will see you in the next video. Goodbye.